Great. So once again, my name is Konrad Siemaszko. I work for the Helsinki Foundation for Human Rights, and I'm going to present the Sienna work on the legal and human rights requirements for human enhancement technologies. The report itself was prepared chiefly by my colleague, Zuzanna Warso. But first, what are human enhancement technologies? Human enhancement remains a disputed concept, but within the Sienna project, we have adopted in the previous stages of the project the following definition. Human enhancement is a modification aimed at improving human performance and brought about by science-based and/or technology-based interventions in or on the human body. Analysis of the legal and human rights requirements of the human enhancement technologies follow the same objectives and research questions as in the two other technological areas studied in the project. We have first identified legal issues raised by human enhancement based on a literature review. Then we've analyzed relevant international and regional norms with a particular focus on the EU level. Furthermore, based on the common guidelines, 12 country reports were prepared on both EU and non-EU states that you can see on the map on the right. And having identified some of the challenges and gaps, we have also formulated some preliminary recommendations on the possible ways to address them. We have identified 7 broad categories of issues, starting from the appropriate level of regulation for the pre-market approval that ought to govern human enhancement technologies, with a distinction between devices and drugs. Though these two groups don't encompass all classes of human enhancement technologies, they do represent a demarcation that is currently recognized by law and largely followed by legal scholars. For instance, we've noticed a discussion whether a threshold for approval for human enhancement devices should be stricter, less strict, or equally strict as for the medical devices. Should the acceptable risk be lower, since there are no clear medical advantages that justify the risk, or on the contrary, since there are no medical needs in the sense of a necessity or pressure, then the acceptance of the risk is more of a matter of individual choice. Other issues included the questions of civil liability. Once the human enhancement technology is already on the market, that questions who is liable for the harm that occur as a result of their use. They implicate possibly both the product liability issues for harms caused by a defective product, and they may implicate professional liability issues, given that they may include services offered by medical professionals or other professionals. There's also a number of legal questions regarding the ownership of enhancement devices that have been incorporated into a human body, or questions whether such technologies may be patentable. Human enhancement raises also some security concerns that have potential to implicate criminal liability. For instance, with regard to unlawful access to implants, or denial of service attacks on implants, or misuse of personal data collected by enhancement wearable devices. There's also a whole area of employment law issues and family law issues. For example, employees may feel pressured to enhance to remain competitive on the market. And it seems prima facie that the status of being enhanced or not being enhanced is currently not included in the protected characteristics, so there's the risk of discrimination. And of course, there's a number of human rights challenges, starting with the general principle of dignity and principle of self-determination, up to more specific issues such as right to privacy, protection of physical and mental integrity, data protection, or protection from discrimination. And to provide you some snapshots of the results, the analysis has indicated a common thread at all 3 levels: international level, regional level, and national level. How to balance guarantees of individual autonomy with a need to ensure safety while also remaining mindful of wider societal impacts of human enhancement technologies. The international human rights norms provide some guidance, but only to a limited extent. Although they constitute an important normative anchor point, the exact scope of human rights with regard to human enhancement is still yet to be determined. We need to wait for relevant case law, perhaps for specific dedicated soft law, or even for more legal scholarship on these issues. In the European Union, there's also an additional challenge. Question what should be left for the member states to regulate and what should and could be harmonized at the EU level, taking into account the principle of subsidiarity as well as the risk of disparities between the member states. Currently, internal market law remains to play the central role of the human enhancement regulation, as human enhancement products in principle fell within the domain of free movement of goods, while the applications of human enhancement, the human enhancement procedures, principally remain within the scope of member states' competences. It has been also noticed that criteria used for approving products on the market are mainly limited to assessment of medical risks and benefits. In principle, the assessment does not consider other ethical or human rights risks. Moreover, in many jurisdictions, there's a recurring challenge of providing a clear demarcation between treatment and enhancement, what is not only a theoretical issue, but what may give rise to a gray zones where it is unclear which legal provision should apply, what standards of care should apply, or what standards of accountability. Having identified some of these challenges, we have also proposed a few preliminary ideas on the way forward. The right to physical and mental integrity, as envisaged among others in the EU Charter of Fundamental Rights, may play a guiding role in the efforts to regulate human enhancement, as human enhancement occurs via intervention in or on the human body, as well as since the right to physical and mental integrity is in itself a cluster of rights relevant to human enhancement, such as it includes such rights as the right to privacy, prohibition from treatment, and the right to health. Having in mind a number of issues that the human enhancement products may raise, it may be worth to consider a more nuanced approach to risk-benefit analysis, to consider a model that will encompass in the assessment different ethical, societal, and human rights impacts, not only medical safety and efficacy issues. Having said that, safety remains one of the key issues, and it's especially crucial to protect it in the gray zones I've mentioned, in the field of providing human enhancement services or procedures. It is needed to guarantee that individuals undergoing these human enhancement procedures will benefit from the established safeguards in the biomedicine field, such as the right to obtain clear information about the risks involved in the procedure, or the requirement that the procedure, human enhancement procedure, is conducted by a trained professional who can be held accountable. And as a final remark, regulating enhancement, it is important to keep in mind that different human enhancement products, procedures, entails different types of risks and different level of risk. So again, it's crucial to keep a nuanced approach and perhaps develop a categorization based on such criteria as enhancement invasiveness, complexity, whether it's permanent, what kind of health risks it might entail, and also its social acceptability. Thank you for your attention. I'll be happy to answer your question afterwards.